Hello and welcome to the Brooklyn Rail's Common Ground. I'm Malva Kajali, Special Projects Associate here at the Rail, and today I have the pleasure and privilege of welcoming Professor of Law Amy Adler, art historian and attorney Virginia Rutledge, and Rail Editor-at-Large Joan Kee for a conversation on Una stanza per Panza, an essay by Donald Judd published as a special edition in the October issue of the Rail. We're also lucky to have poet and writer Sarah Ghazal Ali here with us today, who will also read to close us out in style. A few quick notes before we get started. We'd like to start by thanking the Dermot Company for supporting this month of the new social environment. You can learn more about them and the Rail's curatorial projects at 66 Rockwell through the links I'll drop in the chat. We've started out all of our events here with two important acknowledgements. The first is that here in New York, we're on Lenapehoking, the unceded land and waters of the Wapinger, Canarsie, Munsee, and Lenni Lenape people of the Delaware Nation and the Shinnecock Indian Nation. The second is an acknowledgement that Black Lives Matter, and it's worth taking a moment to remember that the heart of both of these acknowledgements is a commitment to the liberation of the oppressed and solidarity for all those who struggle for freedom, in recognition that when it comes to our liberation, our histories never unfold in isolation. That thought coming from the lovely Angela Davis. In that spirit, I'll drop in the chat in a moment a living document of resources and actions. But now it's my honor to introduce our wonderful panelists of this afternoon. Emily Kempin, Professor of Law at NYU School of Law. Amy Adler teaches art law, First Amendment law, and feminist jurisprudence. A leading expert on the intersection of art and law at which we are all convening together today. Adler has lectured to a wide variety of audiences, ranging from attorneys general to museum curators. She's joined today by art historian and attorney Virginia Rutledge, who has also made a life at that intersectional space of art and law. Previously a curator for LACMA, a litigator at Kravitz, Swain and Moore, and vice president and general counsel of Creative Commons. Rutledge now works in private practice, where she focuses on intellectual property, contemporary art, and cultural organizations. I also want to mention we also have the privilege of having Caitlin Murray, Director of Archives and Programs at Judd Foundation, here in the audience with us today to support and to guide us. Murray is the co-editor of Donald Judd Writings and Donald Judd Interviews, and wrote the beautiful historical introduction to Una stanza per Panza in our most recent issue of the Rail. And lastly, keeping them in conversation and in questions, we have Professor Joan Kee, who teaches at the History of Art at the University of Michigan and was the Robert Sterling Clark Visiting Professor at Williams College earlier this year. Her books include Models of Integrity, Art and Law in Post-60s America, and Contemporary Korean Art, Tansakwa and the Urgency of Method. She's the guest editor of Why Art and Law, a special issue of Law and Literature forthcoming later this year, a volunteer lawyer in Detroit, tuning in from the Rail offices. She is an editor-at-large for the Brooklyn Rail. Joan, everyone, take it away.
Great. Thank you so much to the Rail team and also to my fellow panelists for joining us today. I think we probably will end up running out of time, but one of the things that's interesting about this text by Donald Judd, I was thinking, what sort of genre would it fall into? It reads like a crypto legal brief, it's an essay, it's a polemic, and it also comes, it's published in 1990. And I've just, before we get into conversation, I just wanted to flag a few things. So this is a year where there's an unprecedented level of legislative scrutiny of creative authorship and ownership. So one good example would be Senator Edward Kennedy. He's trying to introduce this artists' rights bill, which would protect artists from having their works damaged by what in the text describes as irresponsible owners. There is also the Copyright Justice Act that was being debated, which was an attempt to get around certain provisions that would let employers commission artworks, which they would have total control over. And so these are some of the questions that bookend Una stanza per Panza. Another sort of angle to think about is that, so in the early 1990s, this is when you had increased gallery efforts to monetize that which was considered unmonetizable. So for example, documentations of performances. So those started to become, those started to be editioned, to be bought and sold. And also of artists having to establish different relationships with collectors. So one example that we might want to think about in relation to Donald Judd is someone like Felix Gonzalez Torres. So for him, his certificates were about, the installation could take any number of manifestations. So in some ways, it might be interesting to think about Judd in relation to Gonzalez Torres. But then there's also the question of respect and trust, that you also have a situation where collectors are increasingly perceiving artists as service providers. And I think this is one of the sub-themes in Una stanza per Panza, that towards the end of this very sort of long, kind of mighty text, is a real sense of just not only grievance, but just real sort of irritation about how the status of the artist seems to be compromised to an extent with which Judd was not comfortable. And last but not least, but I thought this would be a nice transition, is that 1990 is the year that MIT Press publishes documents related to the destruction of Richard Serra's Tilted Arc. So Tilted Arc being a site-specific sculpture that once stood in lower New York, being removed at the behest of the US government. And so in some ways that has served as something of a bellwether in terms of thinking about, well, what are artists' rights? And I think this is a kind of a good segue to think about the nature of moral rights, on which both Virginia and Amy, you are, again, I don't know who better to talk about the question of moral rights than both of you. So for members of our audience, so moral rights refers to non-economic rights that vest in, say, creators of copyrighted work. So for example, that if it includes things like rights of attribution, that you have a right to have the work, you as a creator have a right to be known for your work, that your work cannot be mutilated or destroyed. So these are some questions that I wanted to bring forth on the table. One is to also think about whether Una stanza per Panza is actually an argument for moral rights, given Judd's long history in supporting artists' rights at large.
I think that's a beautiful question, and perhaps you could pass the mic around just to kick us off in style.
Shall I start? I first have to say I'm so delighted to be here, and I'm so just delighted to be in conversation with Joan and Virginia, two people whose views on art and law I respect so much and admire. So I'm excited for this conversation. And Joan, I think a couple of responses to your very provocative introduction. In trying to think of the genre of this piece, I think that's a really interesting question. I might think of it as a kind of howl, and maybe a howl of, to me, a very poignant howl, trying to grasp on to an image of the artist and the art world that I think was slipping away, and that in the wake of the 80s art market was in many ways a prescient howl about the role that the market would come to play. But I loved your pointing out about the time of this piece, 1990, because I agree so much with this positioning, this work, and I think in particular the idea of moral rights, which I'd love for us to talk more about. I think this is a text that really perfectly encapsulates the ethos of this idea of moral rights, the anti-copyright view incorporated into the Copyright Act about a work of art as sacred, as beyond the market, as deeply connected to the artist's soul. The work of art as the artist's child, as a personality right, as something that the artist has profound connection with beyond any sale of the work. It's really underlies the idea of moral rights, and the act of encapsulating moral rights in US law was passed in 1990, the Visual Artists' Rights Act, which I hope we can talk even more about. But I think to a large extent that act would have actually helped Sarah, that I think he probably had a claim under that act that he didn't, because these problems preceded it. And I think the idea of Sarah is very interesting, this longing for permanence and control, and Sarah appearing in the work. Another thing that I think I was thinking about at this text is how much it's also an aspect of that moment when there was such a battle about government funding of the arts, and thinking about art as free speech, which was in fact the claim that Richard Serra brought in trying to stop the government from destroying his sculpture, and the time of Mapplethorpe, and all of these debates about freedom of speech that I think are also a very interesting background in which to contextualize this extraordinary text or howl.
Shall I just throw in a few more things that we might want to talk about? I'm also noting it's a different kind of time, but when Una Stanza was written, out there in the world for almost 2 decades had been Seth Siegelaub's model contract, the artist reserves rights transfer and sale agreement. And I think it's interesting that there's no acknowledgement of that out there as a model for precisely some of the collective feeling about the project of art, capital A. Why was that such a fail? Because it certainly was a fail, is a question worth asking, I think, still today, because I'm also wondering if this piece were published today, now almost 30 years later, what kind of reception would it get now? I mean, we actually haven't moved the needle very far at all, with some fantastic exceptions in the legal and the art history adjacent legal worlds on substantive discussion of some of these issues. Mm-hmm. In the studio or in the MFA studio level, I don't think very much has changed. And I certainly don't think it's changed for the better in terms of awareness, either of artists' rights or knowledge of allies. So, the how may not come until you get into trouble, with the first gallery representation and somebody realizes, I've actually really not thought through what it meant that the work might still exist once it's deinstalled, but gee, did that purchase contract or invoice make all that clear? And do we now have an issue about this? I mean, that was my morning, by the way. So those were beautiful questions to set us up with, Joan. And I think this howl, which I very much love, Amy, is as relevant today as it was 30 years ago.
And to those here in the audience, I've dropped a link to the essay, which is quite extraordinary, in the chat. But I was wondering, as we're kicking off, do you think we could get a little summation of the essay for those in the audience who perhaps haven't read it yet?
It's hard to sum up. I mean, the best way to, I guess, think about it. So one, it's very long. It's about 35 pages. And it starts out with, again, Judd's grievances against Giuseppe Panza. So the well-known Italian collector who would, and this is not just limited to Judd, that he would actually purchase certificates or instructions from different artists. And he has sort of a long and checkered history of thinking that when he buys a certificate of authenticity or the right to make the work, that in itself is the work on its own. And one thing to also just kind of that's quite interesting is that this is a long essay that also touches upon questions of politics, about, say, the role of artists in culture and society at large. So it's not just, say, kind of a sort of a localized essay, but really thinking about what is the role of the artist here, given all of these sorts of watershed changes in, say, economic expansion, say, he even talks about US politics, that he's also really trying to have his readers think about, so what has the artist become and what sort of futures do we want artists to participate in, if given the sort of the state of the world. So I think it's good to think about this long essay, not just as a very sort of point by point objection of all the sort of things that Panza has done, but also how is it that he's trying to think about what is sort of the role of the artist in a society that is really kind of bringing all sorts of pressures to bear. So treating the artwork as merely, say, a tool for exchange, or thinking about how is it that the artist is somehow now subordinate to a collector or to an institution. So it's hard to sum up, but it's really kind of, it felt very sort of retrospective to me. And I think, I'd love to hear what Virginia thought of this piece also, given her dual backgrounds in both art history and legal practice.
Well, there are a lot of ways to go with this question, but I'm still thinking about something Amy said, which will be my circling back to answering that, is if, as is often the case, we still seem to have a divide between the art world, whatever the art world may be, and the law, which is perhaps a much tighter container in some ways, we still have some serious vocabulary problems. It never ceases to amaze me that even within Judd's piece, where he's writing as a kind of historian of his own and others' art, do you come away knowing what, for example, site specificity really means? Mm-hmm. And that is crucial to understanding what the artist really wants in many cases. And it could also be crucial to understanding whether there's been a true meeting of the minds between, the purchaser and the artist. Mm. And it's also something we're still grappling with around moral rights and the way they're dealt with in American law. Mm. So I guess as reading with those two lenses, the art history lens and the legal lens, I am always frustrated that there seems to be so many gaps between the two. And I do have to be a bit of a fangirl here. And just for those who have not read Joan's most recent book, it's a model of writing between those two worlds and getting them both incredibly right. And Amy similarly has done a fantastic job, especially I think in her work on moral rights and making clear what the stakes ought to be that we're talking about. But I just don't feel like we ever really get to talking about it too much. So that's why I was very happy to jump in, on this particular question. I don't have an answer. But the attempt to do the legislation in 1990 really hasn't moved us that far down the path. And some of us think we shouldn't even be on that path. So.
I'll just say I agreed about Joan's magnificent book. In terms of site specificity, which, it's interesting that I think in many ways, a difficult artistic concept, watching courts try to understand what that means. And I think failing so miserably has been something that I see again and again in some of the prominent cases. And this was actually a significant aspect of the Sarah case. So just to go back a second, moral rights, again, this statute passed in 1990, the Visual Artists' Rights Act of 1990, which I think would have protected Sarah in some of the issues he had with Panza, states that an artist has the right to the integrity of his work. And I'm going to use his advisedly, and I'll explain in a minute, of his work. Because again, this vision that the artist is tied to that work in a spiritual, non-economic way, and can prevent the modification or destruction of that work, with certain exceptions, which I'll talk about. But that also gives the right of attribution to an artist, the artist's right to insist that his name be connected with the work of art always. And this is derives from a French right called the right of paternity. So really this kind of macho, I think, very macho concept, but to insist his name always be connected with the work, and also to insist that his work, that his name not be used in connection with a work that he didn't create. So I think in Judd's case, where he thinks that Panza and argues that Panza has fabricated work that is not his and takes out this ad saying it's not mine and writes this howl against it, under the Visual Artists' Rights Act, which was passed after this essay was written, he could have actually sued Panza, at least for this right of what's called a negative right of attribution, and insisted that Panza not call the work a Judd. But the other thing that's just going back to Sarah for a second, Sarah was really arguing that, and it was key to the lawsuit, although, or at least to the undertone of the lawsuit, what Sarah was really arguing was that the work was, that the government was destroying his tilted arc. And I don't know if everybody knows tilted arc, this great hulking, quite aggressive Sarah that was built down here in Federal Plaza and meant to be permanent. And was ultimately dismantled and, according to Sarah, destroyed by the government because it was taken out of its site-specific space. And nonetheless, in spite of Sarah's insistence that moving the sculpture was a misnomer, that the sculpture was being destroyed, not relocated, the court couldn't understand that. The court kept saying, well, we're going to move it somewhere else. We're relocating it. We're not harming the sculpture. Failing to understand this site specificity argument that was, I think, essential to the artistic integrity, again, of Sarah's work. So this, just to go back to your point, Virginia, about this gap in vocabulary, this gap in translation that we see around works of art and legal adjudication of art.
Actually, thinking about that gap, Virginia, given your long and storied practice as, it was really kind of one of the pioneers of, art and law. How have you encountered, say, similar situations in your practice? And I was also wondering about, so Judd is very reluctant to, file a lawsuit. And I'm just wondering if, say, negotiation might have been or if he had known about negotiation theory, would that have been a more useful tack?
That's such a great question. I never met Donald Judd, but I do I do work with many artists who have similarly strong feelings, but perhaps not the position from which to speak. I mean, that was a pretty amazing thing to be able to publish in a stanza, for one thing. So I think something we always have to keep in mind is, if we don't have a legislative structure, a legal regime that sets standards for everybody, there's always going to be a question of who's got the balance of power if we are setting it up in a negotiating kind of system. So in short, yeah, I do this stuff all the time. And one of the frustrations that I know I've talked with you and Amy about at different moments in different panels is that when you're in private practice, particularly if you're good at helping people get to a solution that doesn't involve litigation, very often you're not actually able to share your success stories, except to the collectors directly involved. And if they're collecting at a high level or sit on the boards of museums, which is often the case, that's helpful. But there is an accumulation of deals and resolutions that even my small office has done over the last, I would say, decade in particular, that could count as a set of here are things to be done, but it's not possible to share it. Sometimes we request confidentiality, and I should say I'm on every side of this. I may represent the artist or the museum or the collector. Conflicts, waivers are really good things to have in these situations, but it's a personal frustration for me, and I know I'm not alone in that. We feel like there are so many different ways to approach some of these problems. There's maybe even the beginnings of some working definitions for things that we need, such as site specificity, among a small group, but it doesn't travel. We can't travel it. So how do we do this? And in the pre-check, there was a little discussion of, how candid can we be? I'll just say it. It won't be for the first time, but I think we need our professional organizations, as long as we're participating in this particular structure, call it capitalism or whatever, the art industrial complex. We could use some more professional organizations speaking up, making it easier for people to articulate their own positions, either aligned with or against. And that's why these conversations that the Brooklyn Rail are holding are so valuable, I think, because they bring in so many people working in so many different ways. But am I sounding sour and frustrated? I suddenly am feeling very gloomy. But today we solved a problem that would have resulted in a work that actually has been known in the world. It's been exhibited elsewhere, but a problem arose, and one solution was, well, let's just forget about it. Let's just let it go. And as an art historian, I'm always going to be on the side of, let's keep those decommissioned artworks hanging around, because we never know when we might want to do something else.
Yeah, actually, on the subject of decommissioned artworks, I mean, this is, where, Amy, your research on questions of the exhibition copy. So it's sort of the gray area where a museum doesn't fully recognize an artwork as an artwork without, say, the asterisk or the qualification. And I'm wondering, say, given what Judd has laid out in, Una Stanza per Panza, but also the Guggenheim's decision to, decommission artworks in the way that one might decommission public art, where upon an artist's written request, an artist can have a work removed. And I'm wondering about your thoughts on that, just because it also circles back to, I think, yours and Virginia's point about the law per se is very different than the law that governs the art world.
Yeah, so I a couple of things. First of all, I think just one very contemporary, one reason I find this text very interesting for us in our moment is that I think it suggests that authenticity might be a much more slippery concept than we once thought. Did Jackson Pollock paint this painting? That's easy. But what does authenticity mean in a world where works are fabricated, not by the artist himself? And I think in some ways there's something poignant about this essay, because Judd is trying so hard to hang on to this very tangible notion of authenticity, just as work is kind of increasingly becoming, I might say, freed from the artist, or no longer so obviously embodied in a work touched by the artist. But I think, again, on this disconnect between artists and law, one of the issues that I've looked at in thinking about disputes over authenticity and the sort of clumsiness of law trying to get around this, I think an interesting example, and this was actually something I wrote about for the Rail a while ago, is Katie Noland, and for an issue that Joan curated. The example of Katie Noland, which also involves a disavowal, where she had this work, and I think many people here know about Katie Noland sort of making an art form, perhaps, of going around disavowing her great work from an earlier era. And so she saw this work coming up for auction called Cowboys Milking, and didn't like the way it had been repaired. It had been damaged and repaired. And even though the conservator for the sale said this work is in very good condition, she said, I disavow this work. It's not mine anymore. And it's interesting because she could have said, I don't like the condition. It could have sold for less, so on and so forth. But instead, she said she basically de-arted the piece, took away its art capacity in a way that I think, again, she invoked moral rights law, the same law that I suggested might have been available to Judd. She said, I am entitled to remove my name from this work, thereby making it, reducing its value to zero and making it no longer a work of art, even though she had created it. And even though it was in very good condition. And I think, again, I'm not sure the statute would actually allow her to do that in the case of a work that she actually made, but that slipperiness and its of what authenticity means and how we should think about the relationship between an artist's word and the actual piece is something that I think we see recurrently, and that even this statute attempting to nail it down is in many ways insufficient to deal with this kind of complex issue of authorship that I think both Sarah raises and the Katie Noland example raises, where disavowing a work that is indeed made by her, is that really what the statute was meant to govern? I don't think so, but I think it's the complexity of authorship is at play.
Actually, I was going to ask both you and Virginia too, is that thinking about other ways to resolve these sorts of situations that don't involve very expensive lawsuits. So I know, Amy, you wrote for me, one of the most interesting law journal articles I've read is your article about how shaming can be a tactic for getting someone to do something that they should have done in the first place. And I'm also wondering for you, Virginia, that even though you can't speak about specific cases, that are there strategies that artists might be able to use to, again, effect change without having to bankrupt themselves on an expensive lawsuit?
Oh, well, shaming is a huge tool in the kit. Absolutely. And of course, that only works if you've got the social power or the moral position from which to shame. So it's helpful if you have access to, again, a museum board, for example, or if you can point to allies, and we're back to the, collective bargaining potential problem. I wanted to add one thing also to throw into this mix that comes out clearly when you look at critiques, yours and Amy's, of moral rights. Which artist are we talking about? Because one thing that became very clear to those of us who have looked pretty deeply now at the records of the Guggenheim that are related to Panza's collection that was acquired, is that the artist is not a stable identity necessarily over time either. Now, Judd, I think, is an exception to that. There is a vision and a practice there that is very, very consistent to my eye and to my history knowledge all the way through. But I'm not being in any way indiscreet to point to the example of Robert Morris, for whom things are very, very much in flux. So at what point does an artist get to exert a withdrawal right? I mean, what about the collector who may actually have made it possible to fabricate the work at that time? Those balances need to be brought into play. And I think Amy's right. The statute is useless on its face for determining whether a really dinged up corner of a shiny Katie Noland metal piece is art anymore by her standards. So what to do? I mean, we're talking.
Yeah, I mean, I think, again, this just adding to what you said, Virginia, there is this insistence by Judd on, the artist's word is supreme. And I think that's very intuitive. It's how could it be otherwise? But the example of Morris, which so well, about Morris changing your mind, I'm thinking of LeWitt as another example of an artist who really has different views of what an authentic LeWitt is at different stages in his career. I think early on, anyone can make a LeWitt, and later he's changing his mind. So which artist do we listen to when we determine, whether something is a work? And I mean, this really, I think, seems like sacrilege to say, but what about if an artist lies? And I'm thinking in particular of a work, an old-fashioned work of art by Balthus, a sketch for painting, in which Balthus disavowed the work. And the speculation is that he did so because his ex-wife was selling it. And he had previously stated, it was real, and changes his mind. And then the work, as becomes valueless simply by this sweep of the artist's hand. So this extraordinary authorial control that that Judd envisions, I think itself raises questions about, is it possible to go too far? Should we perhaps listen to curators who say, those early LeWitts that were made, by anyone, maybe they're, or the Morris, I think, is probably a better example that Virginia raises. Should we suddenly trash these works just because Morris changed his mind? What do we do with them?
Please go ahead.
No, I was just thinking about the LeWitt example. I am allowed to share that I do work with the LeWitts, and one difference between what ended up with the rules about Saul's work and, say, Morris's work was he made a conscious decision to standardize, to put it into these kinds of very pragmatic terms. So, an artist does have the ability and a lot of power to decide that in some cases, uncertainty or ambiguity is not serving the work, and to take the tedious, boring legal tactic possibly of writing things down in a way that can more easily be replicated. But should we have to do that all the time? I guess it goes back to, that question of, shouldn't I just be able to say so if you buy into that particular theory of authorship? Administratively, all of this is a nightmare one way or the other. But the artist has a lot more control, I think, about the terms of their own work than we sometimes think we do, even at the most practical level. And sometimes that happens in places where you might not expect. For example, okay, I am gonna sound sour and gloomy, but I'm gonna do it anyway. For every, great experience with a museum institution where there's curators and administrations, and I see some in the guest room here who are just, exemplary in this regard, to make sure that they understand. There are also places where artists get bashed around a little bit, and how willing really are these choices, when the choice is to be exhibited or not exhibited, or to have your installation partially completed or not at all, I think is something we need to be open about. Many times artists are asked to waive their moral rights. And that may be completely appropriate in some situations, but isn't it something we should be actually talking about?
And also, what are the role of gallerists and dealers? Because in going through the Panza papers, one thing that was striking was, in some ways, that it was the dealer who would kind of egg Panza on to say, tell me that my ownership rights are vested in full. That for some artists, I'm thinking about Michael Asher and Robert Barry, that it was actually the dealer who would kind of tell Panza, you should be demanding X, Y, and Z. And so I'm wondering, given the enormous sort of economic pressures that so many artists are facing, how do we deal with that kind of situation?
I might, if I may, turn this back to you, Joan, because building on what you were just saying and what Virginia was saying as well about the artist, trying to standardize this, I think of you as the great thinker on artist contracts, and I wonder if you have anything to say about the paper that that Judd used here, and quasi, I don't know, was it a contract? What was it? The way he memorialized this work, its insufficiencies, and he was represented by Seth Siegel, as I recall, right? So I'm just curious to ask you, because you know so much about this issue of artist contracts, the expert.
One thing is, maybe that contracts need to be more made more of a habit, just because. So in, say, the early 1990s, to my knowledge, contracts generally were not used. That it occasionally, usually was regarding consignment of artworks to galleries. The one exception might be, say, Michael Asher. So Michael Asher worked very closely with an attorney who went line by line over kind of everything that Panza had demanded. And one thing that was quite noticeable that was different from Judd is that what Panza would be purchasing was the full utilization of the right to make the work and to assign that right. And that was actually drafted as a contract. So for members of the audience, for a contract to be legally binding, there has to be an offer of some kind. There has to be acceptance that is voluntary, and there has to be something of value that's exchanged. Without those three components, it is not legally binding. And it seems almost that Panza was, I know he's trained as a lawyer, but I'm thinking probably not a very good one, because it seems that he just misreads, maybe willingly misreads the agreements that he makes with Judd as a binding contract. And so one of the other questions that Una Panza raises, and to me it sort of reads as kind of this one huge attempt to just shame Panza, just not only for being greedy, but also for being an idiot, is that kind of the refusal to read what actually was agreed upon. One of the other interesting parts about Una Stanza per Panza is what happens afterwards. So one good example might be Panza is also in discussions with the conceptual artist Maria Nordman to buy her work. And Nordman is almost taken aback, because Panza actually says in writing, it is necessary for me, Panza, to contact you, the artist, regarding any work to be realized, and it has to be done in your presence. And again, that's not something that you would have found in Panza correspondence before 1990. So I'm thinking whether, Judd's howl of protest is, actually had some effects. But the other thing that, with contracts that, I was thinking about is, does that actually contribute to some kind of alienation between artists and collectors? Because Panza is also quite paranoid. I think he also writes to Maria Nordman, I want you to tell me in writing that you're not going to go and say, disown all this work. I want the assurance that the works will not be distorted by an incorrect realization. So he's clearly stinging from, just really sort of, wounded by what has happened. And so one sort of question here is, to what extent do contracts allow for more certainty between, say, artists, collectors, or say institutions, but also does it have, say, significant drawbacks in terms of, making relationships more confrontational than is necessary? So I just also, these are just some of the questions that I also had for both of you as well, because from the point of view of legal academia and legal practice, that the contracts can look very different. So.
Well, I can tell you that we write really friendly contracts, very easy to read and very, very short. But it is often a situation where basically people feel like they're being asked to negotiate a prenuptial agreement. And with all the stuff that goes on around that, like, we're already contemplating, this isn't going to work out. It's that dynamic is always there. But something really worth focusing on is that dynamic of the collector, whether it's from paranoia or some legal training or good business sense, pushing things in this direction. It's quite interesting when that happens and and how often it does seem to move in that direction. I can say that I've compared notes with a few other practicing lawyers, particularly in the contemporary world. And I believe that we're actually seeing a lot of artists being asked to produce something that gets called a certificate of authenticity, even when it doesn't really have anything to do with the way their work is made, or it doesn't serve as a recipe the way a flavin does, for example, for building the work. It's not, it's just not serving that function at all. It's as if every collector heard from somewhere, well, do you have a certificate of authenticity? And it's sort of like, are we talking about the thing that the grandson of Pissarro signs for a painting certifying its authenticity? Or are we instead talking about, you know, a certificate that is related to more conceptual work? It's as if, well, what's the difference? They don't know. And I think that's a problem, because it really murks up what the work is, you know, in some cases. So these dynamics between those power players, you know, in a particular situation are real, and they have real consequences. They change the way things look in terms of industry practice, and I think even art history has been changed.
Just thinking, hearing what you were saying, I was just thinking about this really interesting case that was ultimately settled involving a lost certificate for the flavin, for a flavin rather. And so, you know, the buyer owns the sculpture but has lost the certificate, and the work ceases to be an artwork by Dan Flavin. So that shifting of the locus of the artwork to the paper, to the document, the plans, maybe a contract as well, and that slippery notion again of where is the art, what is the art, that I think Judd's work was certainly not dependent on the paper, but maybe Panza misread his work to be dependent on the paper. On the subject of contracts, I was just teaching a moral rights case that I always talk about contracts with my class. And Joan, you were saying that it used to be the practice not to, you know, that contracts were rare. And it's the case involving Christophe Buchel and his case against Mass Mocha, where, for those of you who don't know, that the artist agreed to do an extraordinarily ambitious installation at Mass Mocha. It was, you know, took a long time to produce. It was produced in part while he was in Switzerland, and workers at Mass Mocha were creating it, installing it. And at some point, the relationship broke down, and Buchel said, well, actually, he was sued, but ultimately he countersued and said, you have violated my moral rights. You have created a work that is not representative of my true intention. And an extraordinary case on a number of levels, partly because I think what Buchel was actually asking for was an aspect of moral rights that we don't have, an aspect in which it's a European idea that the artist has the right to decide whether and when a work is complete forever. That you can't, it's different from the right of attribution. It's saying this work isn't done yet. Not an American right, but a European right. But the other interesting thing about that case is that Mass Mocha did not make contracts with its artists. And that was a conscious choice. And I think it represents, again, not just, I love the analogy to the prenup that you were making, Virginia, but I think it's also this idea, to me, it seems to reflect an idea that perhaps is consistent with what Panza, what Judd was saying in the Stanza per Panza essay, that I'm not going to reduce my work of art to mere paper. You know, that there's something dirty about a contract for this again, to use the language of moral rights, this is my child. I'm not just going to make a contract about my child. This is beyond commerce, and then contracts as the language of commerce that seems, I think, explains partly why it's extraordinary how many times we see art agreements done on a handshake and not an actual contract.
Mm-hmm. I mean, that's kind of also extraordinary too, is the Mass Mocha case, is that, they're so given the sums of money involved, and I know, Virginia, you've also written extensively about this, and not to have anything in writing is just, I don't know, it's almost mind-boggling, or I don't know, maybe what is it? Maybe is it too much to ask that both parties sort of foresee what some of the contingencies might be before entering such an expensive project?
It's interesting, especially when it's a nonprofit, publicly supported by tax dollars. I think it's in this day and age prudent, to do this. And of course, Mass Mocha, to my knowledge, does now use contracts. So something changed there along the way. But that point was precisely made by the director at the time that Amy made, of like, well, we don't need to do this. Essentially, it was a point of pride that we don't have contracts with the artists for this. And one can feel a lot of sympathy for that. I mean, aren't museums in particular on the side of the artist? I mean, do we really have to question this? So something else that's driving the rise of contracts, at least from the perspective that I see, is increasing concerns about intellectual property and questions of rights around licensing, particularly as some artists are able, to exploit a copyright in a way that didn't seem conceivable 40 years ago, let's say. Museums often have to be very conscious of risks and make sure that they have the rights to use what they think they will need to do. And that too drives part of this process about talking. Well, if we're going to have a discussion about, image use, shouldn't we also have a discussion about, no, I really mean that always has to be fresh, gluten-free, flour there, not something else. So.
Malvika, did you want to turn to questions? I see there are a couple of questions in the Q&A.
Sure. Well, I was going to say, if you wanted to take another 5 minutes, this is so fascinating, and Q&A is kind of rounding out right now. Oh,
sure. Yeah, no, I have lots of questions. One question I had actually for both of you, and this is sort of a more, general question. So, on the one hand, that Una Stanza per Panza, it's like Siegelob's, resale rights agreement. I mean, it did a great service, and basically letting other artists know, hey, there's some rights you should probably be aware of, and these are some situations you should be aware of. But on the other hand, I'm wondering, do you think we're moving? How much regulation do you think is necessary? So even though we see the need for contracts, do you also perhaps see a point where too much writing or too much, preemptive regulation might have some sort of dampening effect on sort of the flexibility or looseness that allows artworks to grow organically?
I have something to say on this, and I don't, as you guys know, I've written an article called Against Moral Rights, in which I've argued that the downside of this extraordinary authorial control, which, and this is, I'm not sure, it's meant to be a provocation rather than a proposal for law reform, but to consider the possibility for play and growth that it precludes by allowing the author to clamp down on the work. And again, the idea is, well, if the work of art is the artist's child, at what point, can we say the child has grown up, it's left home, it's, met with other children, it's, had some new ideas of its own, its parents never understood it anyway, maybe the person it meets next will understood it better, and how should we think about that? And I think that's important as we get to a more maybe readerly view of art, the artwork is being open to revision and recontextualization by the viewer. And I'm thinking even with Panza, as much as he was, I think, clearly misinterpreting Judd, other artists whom he collected in that period, I think, were more open to his misreadings or his, misassemblies, and for example, Bruce Nauman was kind of okay with Panza, kind of playing with the plans of the work. And I think Robert Morris too saw, either they accepted the freedom that they of the space between the work and the plans or the written paper. But I don't know if they delighted in it, but it's possible to delight in that, to delight in the way misreadings can recreate the work. So, I like to think about a space for misreading, or for letting the artwork rather than the artist speak, even though I think it feels painful to talk about this in the context of Judd, who was so, what can I say, burned.
Virginia, what do you think, having represented clients of every conceivable variety in the art world?
Well, I'm with Amy on liking space for play completely, and it's going to happen anyway. I mean, no matter how nailed down something is, we've all read enough theory to know that we're going to be reinventing the work, whatever the work is intended to be, every time, every generation, every whatever. But I want to be able to honor the intention of someone who is very, very clear, such as Judd. I will confess, I thought I knew the work pretty well, but until being really immersed in the materiality of those things, and that matters in a way that does not matter in quite the same way for many of his peers. I mean, it is extremely precise and significant. I loved, do you remember the part in the stanza where he says, "I hope this is more fun to read, than it is to write"?
Yeah.
Well, it really isn't that fun to read because there's such pain, I feel, in there. But there is this place where he describes, and the fasteners, they're just wrong, they're chic. And I felt like that's right. And I get that now in a way that I would not have before. And if you're an architecture freak, you get this, instantly. But that 1/4 inch reveal at the bottom, that needs to be just the way he wanted it to be. So I don't want anybody to be mucking around with that unless he authorized it in advance, which leads to some very interesting technical questions about contracts. Like, I try not to fight back too much anymore, because what can one do? But your contract says the artist is going to approve this and this and this. Well, how long is that going to last? At what point are we then going to make an archival holographic something, that why are we even in these contracts now focused on an artist approval right when that approval right literally has an expiration date? The ability to do it.
I mean, that's also another question too, is that, okay, so again, that what happens, say, not necessarily for Judd, again, very well established, very rigorously maintained foundation, but what about artists that, again, see the light of institutional day, decades later? Who is going to actually make those final determinations of whether the work is as fully actualized as it should be? I think that's is it, who gets to have that right? Is it this person that buys the work? Is it, say, the copyright holder who may or may not even have an interest in art? I don't know if, I seem to remember, Amy, that you were going to write about this at some point, or maybe I'm completely mistaken.
So I'm not sure which piece you're referring to, but I am writing about a piece about authenticity, in particular about disavowal, and I'm not sure if that's what you were thinking about. I have to say there's another piece that I've been thinking about in the back of my mind, in addition to the shaming thing, which I'm glad you brought up, because shaming is such a legal alternative to law here, and sort of calling attention to these kinds of problems. In some ways, I think more powerful than law now in a digital era. But one thing I'm just wanted to throw out as a possible addendum to my provocation against moral rights. I think about this essay as very poignant for a number of reasons, but in part it's poignant to me because it's such an analog. It's such an analog piece, such a so much about, you know, the specific object. I think about Judd, that you know, the thing that's there. And I'm writing about memes right now, and the vision of authorship that memes depend on, as exactly opposite to this view that that Judd, again, I think embodies. The idea of the meme is no one owns it, no one controls it, it's constantly changing. It really is this work that's left home. It's this work that's meeting up with other memes and merging and having its own children and messy, you know, messy couplings. And the idea of an author in control of the work is the opposite. So much so that I think in some ways this new boom for NFTs is actually a way of a longing for some idea of stasis and permanence, to use Judd's words, and to stop this endless flux of movement of a work. So I'll just throw that out there again about this poignant and I think old-fashioned vision of authorship that undergirds Judd. Not that people still don't adhere to it, but that an alternative model of creativity is really with us, certainly in pop culture.
And yeah, what you said about the permanence issue, you know, Donald Judd in 1982 wrote an article called The Importance of Permanence, where he talks about art lacking any sort of legal autonomy. And it's also an essay that talks about, well, how can we revise some of our laws and also attitudes to make it easier for artists to, again, actualize their work and basically die with some certainty that that actualization will take place even, you know, well after that they're gone. Virginia, would you like to add anything else before we move to you know, questions? I think we have quite a few. Well, actually, on that note, Malvika, should we turn to questions? Because there's one that I think is almost really tailor-made for, especially for Virginia. And that's actually your question when you talk about, when we, you know, think about how is it that the law with a capital L is different than law that operates in the art world. And you asked, you know, since we're in a room with young artists and cultural workers, can you share some examples in which that's true? And also, what are some things that you would like to impart that might be of value to young artists? And I'd love to hear from Virginia, especially, because you have had feet in so many different domains.
Thanks. I really do care about this question so much. And it's challenging because the simple answer is transparency. You know, let's just talk about what everybody's doing. Let's collaboratively, you know, solve these problems. And at their best, I think museums do that when they work with their colleagues and they try to work with, you know, artists. And then since those tend to be sometimes more public situations, that information gets out. But there's just an incredible amount of waste around this stuff. Like, you know, the basic contracting terms are really pretty straightforward. The challenge is the defining of the work, isn't it? So the legal drafting, I think, it's very fetishized and very just kind of overemphasized, when what really needs to happen is the conversation about, here it comes, authorial intent. You know, what do you really want as an artist? Where is this work? And, you know, to capture that in a legal document is more challenging for some than others, but that's definitely where the push is. So for young artists in the room, especially if you're getting an expensive education somewhere that you're having to pay for, I think in the same way that, you know, you've probably taken classes to do with technical skills and such, I don't know why it's not like having to get a driver's license. You know, I think there needs to be more across the board in studio and literary programming about the legal structures that might affect the way you practice. your work. I mean, we've been living through, those who've been fascinated by the kidney donor story, just to mention one, you know, this is everywhere, deciding who owns or gets to own or gets to meme with something should be part of the curriculum. If there's any point in studying any of this at all, that's that I feel strongly.
Actually, just a quick follow-up. So this is another, paraphrasing another question, that where can artists find resources for legal situations, given that not every artist is going to have the well-known lawyers at the ready. Is there, say, what sort of resources are out there, given that organizations like Volunteer Lawyers for the Arts, huge backlog, very long waits. What can artists do to think about their legal needs? And I'm thinking about this in relation to Judd participating in a show called The Artist Rights Exhibition that was actually meant to fundraise to create a legal clinic for economically disenfranchised artists.
Well, you said it. Everybody, including pretty high-powered and deep-pocketed artists, getting representation can be very difficult for everybody. So there aren't enough of those kinds of resources to go around. But if we had fewer questions, we would have fewer problems, I think, going into this. So I do think it goes back to education. So a call out to anybody who sits on a well-endowed foundation board, for example. It would be really great if somebody would put together a standard curriculum. I mean, there are a couple of handbooks out there that are useful, but this area of law in particular is evolving so fast, and it's so important that it be tied to the reality of what happens, in the studio and then into the market, that to me, it feels like it should be a living, ongoing conversation. And, if that was shared around all over the place, it would be pretty helpful. You may remember, and then I will get off this particular soapbox, several years ago when file streaming was newly the thing, the Motion Picture Association did a very effective teaching campaign about what they called copyright infringement or piracy. Extremely well funded, and it misformed some people's ideas about, for example, fair use for a generation. Why can't we in the art world do some things that have that reach and scope?
I'll agree so much. I think the College Art Association is a good resource, at least for institutions, if not for artists themselves. And I think, perhaps even more than a document, maybe a series of lectures that are currently available. Because one thing I'm just thinking about with fair use, which is something I follow very closely, it's changing. It's so murky. And, if we think about this recent decision, a decision in an Andy Warhol case, it's just erased a lot of the pre-existing law. So this is a moving target. And I think for artists who want to incorporate other, images in their work or other objects, it's a really complicated and difficult moment to be doing that kind of work, referencing other works. But lectures, rather than, otherwise, what am I going to say? People go read the Warhol decision and compare it to the Richard Prince decision and figure it out. It's terribly unclear area of law.
Well, thank you all for that answer. And I think next, we'd love to pass the mic to Caitlin Murray, the Director of Archives and Programs at the Judd Foundation, who also wrote the beautiful introduction. Caitlin, take it away.
Thank you. I want to thank the Rail and thank you all for this incredible conversation. I mean, in particular for your close reading of what is Judd's longest essay at over 25,000 words. And I think, Virginia, as you said, that he said that he hopes, Judd wrote that he hoped it would be more fun to read than it was to write. And I think that begs the question, why did Judd write this? Of course, there's the shaming element, which I think is very important, as you guys have brought up. But I think also something that's been fundamental to this conversation is the question of being an advocate and how one advocates, which of course is fundamental to what you guys do in your legal work. But I think what this conversation has helped stimulate is a question of how do we advocate for artists, whether you're an archivist at an artist foundation, you're a curator at a museum, you're an art historian. How do we, I think what Judd wanted to think about was how to keep artists at the center of the conversation, at the core, and how do we do that in our various fields. And I think as someone who's thought a lot about Judd's work and what he's brought to the table in this, and you see the ways in which he as an artist advocated for other artists and their work, whether it's the Richard Serra and the Tilted Arc piece, or the creation of the Chinati Foundation for other artists to be able to present their large-scale works on a permanent basis. And so I think, thinking of that as an example, of course, we can't do things on those scales, but how do we work together from where we're at and the positions of power that we have to create an artist-centered conversation, which I think also goes to the heart of what the Rail does. So I just want to thank you guys for this thinking, and obviously not something that we can answer today, but just consider how we can be advocates legally or otherwise in our work. So thank you all for this. I'm looking forward to more questions.
Brilliant. Well, thank you so much. I have another question I have been wondering about, which I'm hoping you can perhaps provide some guidance. I'm wondering how this discussion of moral rights perhaps trickles down into the topic of repatriation of colonial artifacts. The discussion about the rights of the individual artists. I'm wondering, is there a copyright angle or an angle here that, earlier, Joan, you said that authenticity might be a more slippery concept than what we once thought. And I love the discussion of how the idea of visual rights derives from the French kind of right of paternity. And I'm wondering, is there an application onto kind of repatriating colonial artworks?
Oh, that comment was Amy. Actually, I was also interested in that, just because, given that it was African artworks, a lot of them were never intended to be artworks in the first place, or even seen by human eyes. So, I wonder if that, adds another sort of layer. But I'd be very interested to hear what Amy and Virginia's thoughts are on this, just because, this is something that's become an increasingly difficult issue. Yeah.
Virginia, do you want to start?
Sure, I'm certainly no expert, but what immediately came to mind for me there are also the controversies, for example, that we've seen around use of imagery that is meaningful to someone, whether or not they create it. I'm thinking, of course, of the way the Walker Center handled some questions about the meaning of Sam Durant's scaffold being cited in a particular place. Thank you for your land acknowledgement earlier, by the way. I think that's a very meaningful practice, and I'm delighted that it's being picked up the way it has been in conversations like this. And I don't quite know what to do with that, other than to say that, figuring out who owns what, and there's a fantastic book just out by Martha Buskirk, who I believe did one of these conversations very recently, is the question, what are our rights, as Amy has provocatively focused on, as viewers and audience members, and where, as Caitlin, was really pointing to, where is the artist-centered look? And it is a different question, I think, Malvika, to do with repatriation, because the ownership issue is it's such a different one, and it's so much broader. But again, maybe we can learn from like transparency and intent. I think if somebody's feeling left out of the discussion, we know there's a lot more discussion that needs to be had.
I'll just add, I think, one interesting analogy to the conversation we're having today is that there's this idea of in repatriation in particular, this idea of a deep, almost mystical connection between a culture and its objects. I might say spiritual, that the work embodies the nation or the people who produced it. And once again, I think the analogy is to this vision of the artwork as forever tied to its creator that undergirds moral rights, and that Judd, I think, certainly believed in, that the work and the artist can't be separated because of something almost metaphysical, and that I think is also drives the a lot of the conversation around repatriation. This object is ours forever.
Thank you so much. That's so fascinating. I'm reminded also, almost a year ago, we had a conversation on curatorial activism headed by the wonderful art historian Maura Riley, and in it she had a guest, Wanda Nannybush, who is the curator of Indigenous art at the Art Gallery of Ontario, and she spoke a bit about the curatorial practice of naming of Indigenous artworks, of the inability to name the artist, and like different ways to put that into the label that there was an artist here, though the name has been lost, which I feel like is an interesting touch point, perhaps. But thank you so much. This whole conversation has been truly fascinating, and we're so grateful to you. For our final question, I'll pass the mic to our very own artistic director and publisher, Fong H. Bui. Fong, take the floor.
Thank you. Thank you, Amy.
Hey, Fong.
Thank you, Joan. Amazing you all. I think the question of education and moral implication is a fascinating one. Not long ago, maybe 4 years ago, I have a cousin who got so excited, not really in the art world or the visual culture in general, had gone to Amsterdam to pay visit to look at Rembrandt, and he called me and he said, "I'm so excited to have discovered two of my favorite painters of all time. One name is Van Rijn, and the other is Rembrandt." And I think that's a so you do injustice twice to one artist. It's kind of funny, but it brings back to a very fantastic, series of exchange letters, 5 of them, between Maya Shapiro and his very beloved friend, the great British philosopher Isaiah Berlin, on the subject of Shapiro's rather critical essay. It's called Mr. Berenson Value. It was first to attempt to identify, in order to prolong and enrich his lavish lifestyle, after having already gave so much attribution, the right ones, to all the rest of the Italian Renaissance and Baroque master. Therefore, they're all the misattribution have made. And Shapiro pointed out in that essay, which led to this incredible, amazing exchange of letters, as I mentioned, that was published in the Rail. I think it might have been in 2009, September. I will send you the link. It's fascinating. But in regarding to Joan, who I brought to meet Jonas one night, that's how we bonded when Jonas was still with us. And I don't know, you guys know this book here, this amazing volume that we are thinking about to publish it. It brings back to the prosecution reset, which was published in New York Times in, I believe it was 2005, sometime for maybe in October, by the judge, Gerald Harris, who has successfully prosecuted Jonas for having screened flaming creature. 1964, as you remember, there was a very famous professor named Joseph Castor who defended on his behalf, who taught at the New School, who basically say that it was fantastic lampoon of commercialized sex and everything else, but it's also mythological, and ritualistic, narrative, surround the film more or less, but he failed. So Gerald Harris managed to prosecute Jonas, and I think in the weirdest way, he then apologized to Jonas in 2005, which is so interesting. The reason why after Flaming Creature, Jonas had also shown Le Chien à Moi, Jean Genet only film, as you guys remember, was filmed by Nico Pakatakis, the only film he ever made. And that case was dropped because Genet was being considered a Nobel Prize winner that year. It's so fascinating. So the measure of moral issue is so interesting, and how much censorship have to do with it. So that's my question to you all, really. Censorship, morality, it seems to be hand in hand, sometimes connected. Am I right about this? Amy, maybe we'll begin with you.
Yeah, I've been teaching art law forever, and I actually begin the class with obscenity law, and all the prosecutions against art and film that in the modern iteration of obscenity law were going on, but throughout that history. I'm not sure if this is a satisfactory answer to the very rich question you posed, Fang, but I would say, to me, it's important to start the class that ends up going into these questions of contract and moral rights and copyright and all that by thinking about the free speech questions first, and to think about art as a form of expression, which is, I think can then inform these more intellectual property rights and so forth. It's a framing of art that I find very powerful and can shift our perspective. So that's why I always start with these old-fashioned and peculiar prosecutions.
Great. Virginia?
Virginia, yeah.
Yeah, I have only taught art law a couple of times, but I think that's exactly the right way to frame it. If art's not speech, why are we bothering with this? And so we've got to make sure that we've got a clear understanding of what our society will allow to be valued and what we're going to, be able to say doesn't merit, public attention, or maybe is even entirely illegal.
Well, Fang, sorry, I didn't mean to interrupt. Sorry.
No, not at all. I just, maybe this is taking us way out of a spiral here, but I do worry, and I think I see this embedded in the piece that inspired this conversation, is the artists being pushed to self-censor to some degree by the power structures, whether they're the market or institutional around them, that the artist feels powerless to move in any other way. And I think that's why we are responding to this piece still 30 years later, because we haven't satisfactorily addressed that question. So.
Super true, Virginia. Super true.
Actually, that circles back to Fang, you bringing up Jonas Mekas. So in June 1964, he writes an essay called On the Misery of Community Standards. So at the time, community standards was how the law justified calling the Jack Smith film obscene. And he's saying, well, this is utterly unbelievable, because the whole point of being an artist is you're trying to battle against a community that doesn't want to look forward. And he actually says, and this is his quote, it is not art that has to be measured against these so-called community standards. It is a community that should be measured against art. So in other words, that the community has to make itself accountable to what it is that artists are doing. And I thought, for me, that in some ways that encapsulates what I think about when I think of artistic integrity.
So true. And you know, the Rail was created to elevate and to protect the artists' voices on all fronts. The artist has to be well respected. And just lastly, it's a little humor here. Storm Thurmond, one of the prominent Republican senator, proponent of Jim Crow law, as you guys know, actually demanded Jonas to make several copies so he and his Republican Party member can study over the weekend. So thank you, Virginia. Thank you, Amy. Thank you, Joan. Thank you so much for this wonderful discussion. Grazie mille. Grazie tante. Back to you, Malvika.
Of course, thank you, Fong. I've dropped a link to the full text of the essay on the misery of community standards, which I think we should all take the weekend to read. But thank you all. This has been a fascinating conversation. Please come back on again. And I'm so thrilled to say that here at the Rail, we have a tradition of ending our community events with art, with poetry readings. And today I'm thrilled to welcome our poet laureate of the day, Sarah Ghazal Ali, to the stage. Pakistani-American writer, editor, and educator, Sarah holds an MFA in poetry from the University of Massachusetts Amherst, where she was an MFA Fellow and Juniper Fellow, a recipient of fellowships from 5 Pillars, ISF, the Kenyon Review Writers Workshop, and the 7th Wave. Sarah currently serves as editor-in-chief of Palette Poetry. She lives in California and is drawn like a moth to all things green. And cherished poet laureate, take it away.
Hi, thanks, Malvika. Thank you all so much for having me. And this was such an insightful conversation, and I'm so grateful to be here. And I'm also really excited to comb through this chat now. There's so many links and resources. This was wonderful. So I'm Sarah, and I'll just read 2 poems today. To provide a little bit of context, I am really preoccupied with sacred history, with faith, and lineage, and what kinds of lineages are privileged, which ones do we have access to, which ones are passed down, things like that. So the first poem I'll read has a visual component, and it's called Matrilineage Recovered. Thanks for pulling it up. And so this one's kind of in the form of a family tree, and there's really no one right way to read it, so I'll just read it in whatever way feels right today. Matrilineage Recovered. I came from somewhere resonant. I came from somewhere, a swarming beyond the trees, a field for remembering. I came from somewhere resonant, Achelous sibyls, made to swallow their mothers, Achelous kindred women, sibyls made to be swallowed like sons, blotted, to be swallowed, shrouded, and forgotten. I came from somewhere, a swarming beyond the trees, a field for undoing elisions, a chance. I was called to keep daffodils from dying. I was called to keep singing of the home in my hand. I was called to keep daffodils mindful of their roots, mindful of their abscission. The wound water leaves. The wound water leaves can heal. I came from somewhere resonant, Achelous sibyls made to swallow their mothers, sibyls made to be swallowed like sons blotted, then today my bright life. I remember, a name recalled, a girl revived. I called, back, survives. I'll call Ami. I'll stop there with this one. And then the second poem I'll read, I have printed out. And this one's called Seeing/Hearing. At 5, my father shows me a color-coded model of the brain. We take it apart together, piece by heavy plastic piece. Blue temporal lobe, burrowed within a red bean, the amygdala. Like a seed? Yes, he laughs, where feelings bud. I picture current anger, pleasure amassing in brick and berry, and fear as a clotting kind of dark. The first prick of blood on a thumb. I unlimb my dolls, braid and section their stiff hair. I scratch at their painted eyes, chide them for their lack of anything occipital. I've seen it, pried open the skulls, found them empty. I wish I could be taken apart, thank what keeps me alive inside. Amygdala taken from almond, precise shape of our eyes, mine and his identical but for his laugh lines. Living means I see but the walls of my body. Flesh the furthest point from a formless God, my father never joins me in believing. Each spring he tends fervently his garden, coaxes to life new green. Genesis splits the earth anew. Decreed in old age to bear a son, my namesake trusted the parts she couldn't see. The buds God insisted were there, whole nations within her. From beyond scripture, she returns to crawl through my throat. Her involuntary sound a revelation. I'm frightened, I'm awestruck. She lingers in the periphery, shaded behind doors. Faith a legacy of echoes, every echo a reflection of voice. I still hear her laughter. What I know is the brain's doing. What I believe bewilders me. And I'll stop there. Thank you so much for having me.
Thank you so much, Sarah. I want to share GE's comment in the chat sorry, we're transitioning into a hybrid in-person situation. I want to share GE's comment in the chat, how this allows the poem to read us, how beautiful. This also reminds me of what was said earlier about the legal right to delight in the space of misreadings. Thank you so much, Sarah, for that reading. And thank you so much, Joan, Amy, Virginia, Caitlin, for your generosity and deep knowledge, as well as our greatest thanks for the whole team at the Judd Foundation for all their work behind the scenes. And thank you to all of you who tuned in today in the audience in the chat. I've just dropped again the link to the fantastic essay, Una Stanza for Panza, which as we all know now is a very poignant and prescient howl. As always, we'll share the recording of today's event on our archives and on YouTube, so it'll be available in just a day or two if you should like to revisit this conversation. And we do this every day here at the Rail. So please join us again tomorrow when we're joined by Argentinian-American artist Raquel Rabinovich, alongside Rail Editor-at-Large Anne McCoy and art historian Alex Bacon for a conversation on the exhibition Raquel Rabinovich Portals on view at Hutchinson Modern and Contemporary through November 5th. We'll close that with a poetry reading by Rachel Levitsky, who was just on Poem a Day this morning. And that will be, as always, at 1 p.m. Eastern right here in the Zoom. Other than that, thank you all so much. And I'll invite you now to turn on your microphones in case you'd like to say hello to one another, goodbye on your way out, or anything else that compels you. But thank you so much. This has been a trip. We've all learned so much.
Thank you so much.
Thank you.
Thank you.
Thank you, Amy. Thank you, Joan.
Bye.
Amy. Thank you, Sarah. Thank you, Caitlin. Such beautiful work. Thank you, Virginia.
Caitlin and Andrea, thanks, Judd.
Thank you all so much for this discussion. So
beautiful poem. Thank you.
Virginia. Amazing. Wow. Thank you. Let's get together soon, shall we? Let's do that, okay?
With great pleasure.
Yeah.
Goodbye. Have a beautiful day.
I'm going to take you guys out for lunch at the Rail. Amy and Joan is here now, so let's just do it.
That would be fun.
Yeah, let's do it again. Good to see you. Thank you. Keep up the good work. We love encourage you all.
Yeah, amen.
Thank you. Amen. Yeah.